Welcome to the Success Partner Podcast. I'm Daya Nath, your host and founder of The Success Partner. On this show, we dive into the stories of attorneys, business professionals, and entrepreneurs who have navigated the ups and downs of building successful careers and businesses. From the strategies they've implemented to the challenges they've overcome, we're here to uncover the insights that can help you on your own journey to success. So sit back, relax, and let's get started. Welcome back, everybody, to the Success Partner Podcast. I'm your host, Daya Nath, and today I'm so excited to have John McKenzie here with us. He is in commercial litigation, and he's in back in the DC area. So, I bump around all over the place, and so we're in DC now. So everybody, keep your ears up for if you're all my DMV folks regarding commercial litigation and a lot of other neat stuff that John's going to share with us. So, John, just introduce yourself and tell us what you do.
Sure, thank you, Daya. My name is John McKenzie. I'm a partner at a law firm called Holmes, Costin Marcus, PLLC. We're based in Old Town Alexandria, Virginia. So we are right on King Street, if you're familiar with the area, which is a really cool old historic part of Alexandria and a lot of cool old historic structures. You can get all the way to the Potomac River and see kind of downtown DC. But I've been working there for 3 years, and we specialize in commercial litigation. We do a variety of commercial litigation matters. Right now, I'm working on some business divorces. I'm working on a law firm dispute. I'm working on all types of cool, interesting cases that usually in the dollar amount range of, say, $500,000 to $10 million. We do bigger cases. We can get very big cases, but depending on the scale of the case, we'll bring in a co-counsel if it gets beyond something that our 4-person team can realistically digest in terms of document review and other things. So I feel very grateful to work there. I spent most of my career working for boutiques, but I've also had experience working for state government and also working for a very large law firm. So I kind of had a variety of different things that I've done.
It's awesome to have that really varied background. And for my clients that I've worked with that are starting their own firms, most of them got tired of the bureaucracy. One would think it would be the stress. And of course, there's always stress in big law, but really like not being able to represent who they wanted to represent. So
yeah, absolutely. I think that obviously, for a large law firm, conflicts are a big deal because there's a lot of clients, and firms have different ways to try to handle that in terms of conflict waivers and other things of that nature. But yeah, I think a lot of the stress of being a lawyer is just kind of part of the job, right? Because the job is deadline driven. The deadline is what drives the stress and also the confrontational aspect of it. But that's something that's going to be true of everywhere you work. Doesn't matter if it's big law or small law, you're going to have confrontation and you're going to have deadlines, whether you're at big law or small law. So I think a lot of that stuff, it's just kind of table stakes, part of the job. But the bureaucracy piece of it, yeah, that's something that I feel like, especially as people advance in their career and they want to build their own client base, it becomes more difficult because you've got to navigate all that internal bureaucracy and you have to kind of pick these perfect unicorn clients, and it's sometimes hard to do, right? So it's nice if you can branch out on your own, you can decide what your clients are going to be, right?
Yeah, absolutely. And I agree totally with the boutique firm there. So what's a success story for you? Share something. You don't have to name names, but something that would be indicative of what you bring to your clients.
Yeah, I think that, most of the cases that we have, they're ultimately resolved without a final hearing or a final trial, even though we have a lot of trial experience within the firm. Most of the cases, by the time you're on the eve of trial, I've had cases in other places I've worked that, settled the day of jury selection and the day of maybe even jury's been selected. It's the first day of opening statement and the case gets resolved. But yeah, we've had a couple of cases on the plaintiff side in a prior firm where we got, I thought, very favorable results right before we were having to try the matters. And then there's cases where we on the defense side recently where we had a dismissal, and the dismissal I felt was it was a great dismissal. It was I can't go into the terms very much, but it was something that I think that the client was happy with, and that we worked up the case, and the terms of the settlement are confidential, but it was something where I felt we did the best that could possibly be done on those set of facts. And it was something to bear in mind, of course, when you're in certain jurisdictions, is that motion to dismiss practice varies from jurisdiction to jurisdiction. Courts are very reluctant to dismiss a case, and they'll say, well, we're gonna take it to the trial, right? We're gonna go to trial. On the federal docket, I think it's the opposite. If you're in federal court, they want to get rid of the case a lot of times before you get to a final trial, but in some state courts, it's the opposite. So you're really angling for, what can I do? I'm probably not going to get everything dismissed on motion to dismiss. So what can I do after dismissal to sort of position the case in a favorable way for our client? And I feel like we got a good result doing that. So I was really happy. Like, it's being able to share good news with the client is like really kind of the pinnacle of the job, in my opinion. It's like, it feels so great. For most clients, they're not in the business of litigating. They don't want to litigate.
Right.
Litigating is like a total sideshow. It's a time sink and a money sink for them. And so being able to get out of litigation, even on the plaintiff side, because the plaintiff, to get to that point in time where they're suing, something happened to them where they're really felt like their rights have been impaired in some way or another. And so they've gotten to a point where they're willing to escalate it to court or arbitration. But they're not happy about that, right? If they could turn back time and never have the injury and never have to go to court, then that's what they would have, right? But they don't have that option. So we're doing the next best thing. So telling the plaintiff, we've gotten to a result that we think that you can be happy about. That also is really exciting as well. So, on both sides of the docket, it's wonderful to be able to share that news. And yeah, to me, a good settlement is a settlement for defense is a settlement where you're paying close to nothing, or if you have to pay something as small a fraction as possible of what the sort of face value of the claim was.
Yeah, it makes sense. And I totally agree. It's like a business owner, and I represented business owners too when I was still practicing law. And it's a huge strain and stress on your family and stress on everything. And I was always very careful to sit everybody down and say, look, you say this is what you want and we'll do what you want. And do you really understand everything that's going to happen? And where are your thresholds and how far do you want to go? And the communication is really key.
I agree. You have to be, in my experience, to get the best settlement, you have to be willing to go all the way, because the other side has to believe you're willing to go all the way. So that means working up the case as though you're going to go to trial, even though 90% of cases, let's say, don't go to trial. You still have to work it up like it's going to go to trial. And of course, that entails all the expense and everything else. Not to mention the fact that if you ultimately do take this case to trial, or you take it to dispositive motion practice before the judge, you're putting the case in a third party's hands that you don't control, right? So I actually tell people, have you ever been in a situation where you believe the facts were on your side and the principles were on your side, and yet, nevertheless, you weren't able to convince somebody else that you were right? Right? That happens all the time. That happens in families all the time, and they love you, right? So the judge who does not love you, or the jury who's a stranger to you, they have no incentive to find in your way. And no matter how subjectively passionate you feel about your position, there's no guarantee that your audience is going to feel the same way about it. In fact, it's almost guaranteed they will not have the same passion about it because they don't have a vested interest in it. So you have to understand sort of the limits of your power, and that this isn't a hard science. It's not like chemistry where you put in the same inputs, you always get the same output. I can put the same facts and the same witnesses into court, and I can get totally different outputs based on so many factors that are beyond your control, right?
Yeah, absolutely. It is. It's finding a way to tell people that you're actually more empowered by working this out in some form or fashion than to put it in front of the tribunal and who knows what's actually going to happen. Yeah, they say that like 80% of attorneys overestimate their case or overvalue their chances of winning. And I'm like, well, if there's two sides, and sometimes there's more than two sides, if everybody's putting it as 80%, then our math is way off.
It's funny. I take the exact opposite view. I think that if you have a perfect case with perfect facts and perfect law on your side, you have an 80% chance of winning. And if you have anything less than that, it's probably a 60% chance of winning. And the reason why I say that is because you have a 20% chance of human error, right? Like, the judge could make a mistake. The juries could make a mistake. The witnesses could make a mistake. Even the expert witnesses that you're paying could make a mistake. You as the attorneys could make a mistake. There's all these people involved in the process that are critical to your outcome who could make a mistake. And to say that there's a 1 in 5 chance of there being a sort of dispositive mistake that happens along the way, that to me is probably maybe even underestimating it. Because of that human error element, you have to realize that could be, even if you have everything on your side, there could be a mistake. And maybe you could get it corrected on appeal, but that's another several tens of thousands of dollars at least. And it's going to be a lot more time. So when you get a resolution outside of trial, it's like tied up with a bow on it. There's not going to be any appeals. It's done. And you can move on with your life. And you can get things that you can't get in court, right? You can get agreements. A judge can give you money damages. A judge can give you an injunction. Nothing else really, right? So you can agree to treat yourself in ways that a judge could never treat each other in a way that the judge could never award. So it gives you so much more flexibility and creativity too. That said, you still have to be willing to go all the way, right? That's kind of what makes the agreement possible.
Yeah, So what do you do for fun? What's John's spare time look like?
It's all family stuff, to be honest.
Oh, I love it.
I have 3 kids, right? So like my weekends are, we load up the minivan and it's jam packed with one kid event after another. I have 3 daughters. My oldest daughter is into like travel select soccer. My middle daughter is a gymnast. She's convalescing right now because she broke her elbow. And my youngest daughter is, she's only 6, but she has a little dance class and a little gymnastic class on the weekend. So we usually have like each day of the weekend, 2 to 3 kid events that we have to do. And that's setting aside social events. So really, I'm just like an Uber for my kids on the weekend. That's what I do. I'm like an unpaid Uber. So it's it's fine. I feel like my parents probably did the same thing. And but as a kid, you're oblivious to it. But as an adult, you're like, okay, you're like scheduling your down to the minute what you're going to be doing with your kids that weekend. But I feel like all these commitments, when they feel like you're drinking from the fire hose when you're in this stage of your life, but then when it's over, you miss it, right? You miss this stage. I already missed the little kid moments from my older one. And so I know that all this chaos and craziness is going to come to like an abrupt halt when she goes off to college. And then it's like, I'm going to miss all the craziness that I had to do right now. But that's all I mean, that's my life is like, I go to work, I serve my clients, I do like, events to try to meet people and network, and I do kid stuff. That's my life. And it's really nice. Like, honestly, like I can't say when I had more free time that I was spending it in a better way. Right. I mean, yes. I like having this busyness.
Yeah. Being a dad, job number 1.
Yeah, absolutely. Absolutely.
Well, good. Well, how do people find you when they want to contact you?
I'm very active on LinkedIn. I haven't posted in a week or 2, but generally speaking, I post at least 2 or 3 times a week. I used to post daily, but this kind of goes to the sort of my general philosophy that, the first step of any sales funnel is awareness, right? So how do you build awareness? Of course, you can go to our website, Holmes, Costin Marcus, PLLC, and you can look us up in Alexandria, Virginia, and you can click on a link and get my email that way. But for the most part, I'm on LinkedIn and I'm available on the web and I'm responsive by email. I know that a big complaint among clients oftentimes is their lawyers don't respond to their emails timely. But that to me is like table stakes. You just respond, right? I mean, like, you got to respond. Your client, I mean, under the ethical rules, I think that, you have a duty of communicating with your client at a certain standard. And I think you have to respond to client emails. It might be really short. It might be, I can't address this more fully right now. We should have a call. But, just kind of the basic, this is received, I'll get back in touch with you. If that's what you have to do, you have to do it. But yeah, LinkedIn and my website are the main ways to get in touch with me. I'm also active in local bar events. I try to go to bar events whenever I can, but that's more just kind of happenstance. If you happen to be there, then I'll see you.
That's awesome. Well, thank you so much for being on the show today. For everybody that's listening and watching later on, this has been another episode of the Success Partner Podcast. And I'm your host, Daya Naif. And today we had John McKenzie. So please like and subscribe and stay tuned.
Thank you, Daya.
Thank you for joining us on the Success Partner Podcast. I hope you enjoyed today's conversation and found some valuable takeaways to apply to your own business journey. Remember, this show is brought to you by The Success Partner, where we help small law firms and business owners achieve unparalleled success through strategic guidance, operational excellence, and effective marketing. If you're ready to take your business to the next level, visit thesuccesspartner.net to learn more. Until next time, keep striving for success, and I will see you in the next episode.